Should I put somebody else's name on my safe deposit box? Hi, I'm attorney Steve Reilly, and today we're going to talk about the saga of two different people. One is John, and John decided to have nobody else on his safe deposit box, and that way he believed he was going to prevent anybody from accessing it before he died. And on the other hand, we have Jim, who, based on the advice of somebody at a bank, told him, you ought to have somebody else's name on this so it'll be easier to access after you die. So he put his sister's name on that safe deposit box himself. Well, when John died, since there was nobody else's name on the safe deposit box, his family had to go to the probate court and end up seeking an order to get access to that safe deposit box. And the way the law works, at least here in Connecticut, is you file an application with the probate court, they grant it, and then the bank is given a copy of that order, and then the bank must open it along with the individual is authorized to open it. They must create an inventory together of what's in that box and then return that inventory, or the list of things that were in the safe deposit box, to the bank. So that occurred, and it took the time and expense to go through with that court order and actually get that box open to find out what was in it and get the valuable papers of that individual. Well, on the other hand, Jim decided he would put his sister on that box. And one day Jim was in the hospital and he decided to ask his sister to please go to his safe deposit box and get everything out of there and bring it to him while he was in the hospital. So his sister did, and she brought it to him. And then he looked at it all and said, okay, I want you to put these items back into the safe deposit box, and these other items I'm going to keep with myself. Well, after Jim died, it turned out that they couldn't find a will. A will was nowhere to be found. And everybody assumed, well, they must have had it in the safe deposit box. And to make it even more interesting, Jim's sister was not really going to be the major heir in Jim's will. But Jim was giving his estate to his stepdaughter, who he had raised since she was about 5 years old. So instead now, after Jim died, they looked for the will and couldn't find it. And then it turned out that, did his sister steal it? That was the first impression of everybody else, is that, or for my client, they thought somebody must have taken that will and only the sister had access to that safe deposit box. Well, the question then became, is there or was there not a will? It turned out in the end that we found out enough evidence to show that in fact there was a will at one time in that safe deposit box. So it turned out that based upon that evidence, we were able to get a settlement to our client's satisfaction, our client being the stepson, or stepchild rather. So looking at the two scenarios, on the one hand was somebody who put somebody else's name on it, and it turned out to be a scenario where it ended up in litigation and ended up that perhaps Jim's will would not be probated the way he wanted it, and he would not leave his legacy to the individuals he didn't want without massive litigation. On the other hand, John, who didn't have anybody else's name on it, it caused him added expense, and his estate ended up footing the bill of trying to open that safe deposit box. So which one's better? Well, on the one hand, sometimes banks will try to convince you that you should have somebody else's name on it. Certainly makes it easier for the bank. Sometimes, the bank usually has, you have to sign in to get into that safe deposit box. And, if you have somebody else's name on there, are they going to sign it? But some banks have safe deposit boxes that only require a key in order to enter them, that don't require a signature of any individual. Then the question becomes, what was in that safe deposit box before? The court order ensures, when nobody else had access for John's estate, the court order ensured that you would know exactly what was in that safe deposit box all along. So the question is, do you or do you not have somebody else's name on it? Well, you can see the pros and cons of doing it either one way or the other way. So the moral to the story is, if you're going to have somebody else's name on that safe deposit box, you better make darn sure that that person who has their name on there is somebody that you trust, and that you've already discussed your estate planning desires with your family, so everybody knows how things are supposed to go down, and there are no surprises. If you want to be absolutely sure, and you think there might be some hanky-panky going on after you die, then the best thing to do is not have somebody else's name on it and let the court process take its course. Well, if you like this video, please give it a thumbs up. Or if you want to get more of these videos, then just simply subscribe. And that way, that'll allow you to be notified of additional videos as I get them up on YouTube, and also to be able to spread the word, so to speak, to other people who might find this information interesting. Well, thank you for watching, and have a great day.